All right. Thanks, everybody, so much for joining us today for this webinar discussing the CMS and FCC new one-to-one consent rules and how we can gear up for those changes and navigate this new compliance landscape. Just a few housekeeping matters before we start and diving into everything. You'll see that there is a Q&A section at the bottom of your screen. If during the presentation you have any questions that come up, we will be keeping track of those questions as they pop in. If they pertain to what we're talking about, we'll stop. We might talk about those questions, or we'll wait for some of them at the end to address those at the end. Additionally, this webinar is being recorded. It will be available next week online at our website. So if you know somebody that is interested in this topic and you think this will be useful to them, please let them know that it'll be available on our website next week. So today, like I said, we are talking about the new CMS and FCC one-to-one consent rules. Both CMS and the FCC have been busy over this past year with new rulemakings that are aimed at enhancing the consumers' privacy, and are complicating things for lead generators, TPMOs, and those. Oh, sorry, getting some feedback here. For those people in the space. Specifically, the FCC one-to-one consent rule, we're going to dive into the specifics of that rule, which aim to curb unwanted telemarketing communications by requiring businesses to obtain consent from consumers for each specific seller, and that's important, their seller. And from the CMS side, we're looking at the one-to-one consent rule that they are putting into practice here on October 1st, 2024, which is going to explore CMS rules designed at enhancing patient privacy and ensuring that TPMOs obtain explicit consent before sharing beneficiaries' information with other TPMOs. And before we dive into the talk, just want to make sure you all know, while Aaron and I are very knowledgeable in this area, and we'd love to help you out. This presentation is provided for informational purposes and educational purposes only. It doesn't constitute legal advice. But like I said, we are competent attorneys and would love to help you out. We would recommend that for any legal questions you have, you reach out to your legal counsel, and we would love to offer those services up to you if you choose to take those. But without further ado, I'd like to introduce myself a little bit. My name is Ben Jewell. I'm an attorney here at McMurray & Schuster. We are a consumer protection regulatory compliance firm and defense firm that concentrates in the space of marketing and advertising and data privacy. I'm an associate here. Have been at the firm for about a year now. My year anniversary is coming up here in about the next week. Before this, I was in-house counsel at a large pediatric hospital here in Columbus, Ohio, working in the marketing and advertising space, privacy space, and have brought those skills here to the McMurray & Schuster firm. I'll go ahead and give Aaron a moment to introduce himself before we dive into the exciting new FCC requirements.
Thanks, Ben. Yeah, I'm Aaron Parry. I'm an associate attorney here at McMurray & Schuster. I work mostly on our compliance side, handling marketing, advertising, and data privacy services. Ben, it's that time of year. I know it's our favorite time, football time, fall. It's here. I never want to wish summer away, but it is a fun time of the year. But it also means that certain rules are closer to coming into effect, which whether we like it or not is upon us. So jumping right in first to the FCC's one-to-one consent rule. So back in December of 2023, the FCC adopted its one-to-one consent rule. That essentially, the bottom line here is that lead forms cannot obtain prior express written consent for multiple sellers through a single consent mechanism. You have to get seller-specific consent to make certain calls. We'll talk on when PwC is required, but the updated PwC requirements are really impose specific and onerous requirements on how to get consent. And the kind of crux here is probably best broken down into two questions that will help us sort our obligations under the new rule. The first is when is prior express written consent required? We have different levels of consent under the TCPA, depending on the type of call. We also have a consent obligation for do not call rules. So Ben, when is prior express written consent required?
Yeah, well, I don't leave home without my handy dandy express written consent printout that we have here at the firm, but which we will make available to everyone at the end of the webinar. We'll have a QR code that you can snatch up to give you a little workflow of how you can navigate when prior express written consent is required. So when we're talking about marketing calls and text messages to cell phones using an automatic telephone dialing system or artificial or pre-recorded messages, we're going to need prior express written consent in that scenario. We're also going to need prior express written consent when we're making marketing calls to residential landline phone numbers using pre-recorded messages. And so it's those two instances. So calls to cell phones, ATDS, pre-recorded messages, artificial voice, going to need it. Calls to landlines, marketing calls to landlines with pre-recorded messages, you're going to need prior express written consent. So Aaron, do you want to kind of dive into those specific requirements, those new requirements that the FCC is requiring to obtain prior express written consent?
Yeah. So effective on January 27th, 2025, prior express written consent requires an agreement in writing with the consumer's signature that clearly and conspicuously authorizes one identified seller to deliver telemarketing calls or text to that consumer using the technologies that Ben mentioned, our ATDS or pre-recorded message. The call also must be logically and topically associated with the interaction that prompted the consent. So they've really beefed up the written consent requirements, and they've included some new parts that, to be honest, they didn't really flush out. So taking the first one here, the one identified seller. What in the chain is the one identified seller we're talking about here?
Yeah, so Aaron, we're talking about the ultimate seller. So at the end of the chain, who is selling the products and services that the consumer is consenting to receive information on? That is who we're talking about. That is the seller. And in the context of insurance, we can think of it as we've got the individual agent, but the agency would be the ultimate seller in this context.
Okay, and then they also use this logically and topically associated standard that they didn't really flush out. That they just kind of said it has to be logically and topically associated with the interaction that prompted the consent, and they kind of gave a few examples, never really sorted it out. So what is this logically and topically associated or related standard that they've used here? And
yeah, absolutely. I mean, thanks FCC for continuing to not give specific advice here and allow us to try to navigate this landscape. But so what we're talking about here, obviously they're trying to stop unwanted robocalls and text messages. They want consumers to be receiving calls that they're expecting to get from the people they're expecting to hear from. And so what we need to do, what we need to do here, and what the FCC has kind of told us, is that sellers should limit the content to what consumers would clearly expect from the consent that they're giving. And so an example that they gave is that that the FCC has given is that if a consumer is giving consent to to receive information about car loan comparisons on a comparison shopping website. They're not consenting to other loan consolidation services. In that fashion, if you're filling out a lead form, you're on an online lien form, and you're looking to get information about car insurance, you shouldn't be receiving calls from solar energy companies or receiving calls from other companies that have nothing to do with that specific topic area. And so we're looking at keeping that that vertical the same.
Awesome. That's kind of unfortunate that we didn't get a kind of a bright line definition, but I think that the gist here is understandable. Like you said, we don't want to be getting wild calls that we never imagined we'd receive when we signed up for loan consolidation services. We don't want to get calls about security alarms or moving services or something like that. So the standards now are a bit more onerous. There's a few things that the FCC didn't provide explicit exceptions for. That's for affiliated companies operating under the same corporate umbrella, or for sellers who want to obtain prior express written consent for themselves and for other authorized retailers of the product or other sellers of similar products. But for the most part, the standard is kind of flushed out enough that we kind of have a good roadmap to go down. There's the FTC and has also been busy with rulemakings that impact our prior express written consent. Earlier this year, they had released their updated record keeping requirements. Those updated record keeping rules now impose more specific and onerous record keeping requirements to document consent, and they also include record keeping requirements for other unrelated record keeping rules. And then the FTC also issued their revocation of consent rules earlier this year, and those rules essentially outline exactly what revocations businesses have to honor, how they have to view certain revocations that might not be stop or something that explicitly indicates a revocation. But overall, the rules are designed to make it simpler for consumers to revoke consent, and they help businesses create guidelines that will take these consumer revocations and put them into practice and get them off the list here. So one of the issues with the FCC's one-to-one consent was the interplay between the FCC prior express written consent and the e-sign Act. The order implementing our one-to-one consent standard didn't do a great job at fleshing out exactly how the two overlap. But what we do know is under the e-sign Act, a business cannot provide mandatory written disclosures in an electronic format unless the consumer consents to receive them electronically. So businesses must obtain e-sign consent using a method that indicates the consumer can access and review the mandated disclosures. This e-sign consent also has to have certain mandated content in it that stems from the e-sign Act, but it's only after the consumer provides e-sign consent that the businesses may provide the prior express written consent, written disclosures electronically to obtain the consumer's consent. So overall, it creates this system where we're actually required to get two separate consents now. We have to get our e-signed consent and we have to get our prior express written consent. It's kind of tough to identify the sequencing of this, but I think that our most compliant approach would be to obtain e-signed consent and then obtain our prior express written consent. That may have some significant business impacts. It might not be workable in some models, but overall, I think that separate consent's probably the most the kind of gold standard here.
Right. Just kind of potentially causes some issues from a a consumer experience perspective, and the time it takes and what they're willing to click through as far as going from one screen to the next. So definitely, feel for companies out there trying to figure out obviously how to minimize the risk there, but at the same time having to also balance what's best for their business operations and their customers experience.
Right, because those e-sign consent disclosures, I mean, they require a lot. I mean, you have to describe a lot in those disclosures. It's not something that you can summarize in a single sentence. So trying to find a path that doesn't totally bog down or confuse the consumer is definitely a real issue.
What else are you kind of seeing out there from, obviously the most compliant option being e-sign consents first screen, then move on to the, to the TCPA prior express written consent next. So, what other options are available out there for businesses?
Yeah, I mean, I think a modified approach of kind of that first example that we walked through where you have your e-sign consent as a separate checkbox or separate call to action, and then another method on the same screen, second checkbox or another call to action button that will allow you to obtain prior express written consent. It is kind of that modified approach that essentially accomplishes what we talked about in our first instance of two screens, one for each consent. But this one is kind of making it, once again, trying to help the consumer with ease through the flow. Not try to burden them and confuse them with all these consents. So that second modified approach kind of blends the two so that everything's on the same screen there. Another option that of course runs up the risk chain is to use an enumerated list to get both of your e-sign consent and your prior express written consent. But as we go from getting consents separately, as we try to blend those more, where we of course run into higher risk. So while businesses continue to play around with how best to implement the e-sign consent and prior express written consent, we do know one thing is that a case back in June, the Bradley versus dentalplans.com case prohibited prior express written consent from being given over the phone. But Ben, what's kind of the impact of the Bradley versus dental plans besides the fact that they outright prohibit the prior express written consent over the phone?
Yeah, so I think as we're discussing these e-sign requirements, it's going to be obviously this was a huge case. We got a lot of emails the day that case was decided, and so obviously not being able to get the proper e-sign consent over the phone, and therefore being able to provide the TCPA written disclosures over the phone and get prior express written consent over the phone is going to cause a lot of interesting difficulties for lead generators and aggregators that had a common practice of verifying certain leads over the phone and trying to obtain prior express written consent for the downstream sellers that they're gathering leads for. And so it's obviously not impossible. It's just that if you're going to be doing something like this over the phone, you're going to need to use some combination of email, text messages, some other way to provide these disclosures electronically to the consumers, and we can get pretty creative, but it's going to take the help of some legal counsel to help put a plan in place that's a little bit more, that's not a little bit, but a lot more onerous than simply going through that statement over the phone and getting an oral yes or no over the phone like we were for the past 10 years.
Yeah, and once again, the FCC has not been um, uh, completely informative of how the e-sign and prior express written consent standards interact with each other. Their December order implementing the prior express written consent standard did not go into great detail. They just said that prior express written consent obtained electronically must be in compliance with the e-sign act. So we've had a few cases that have dealt with this issue, but none have hit home as much as the Bradley case. And I think that may be due in large part to the FCC's not so much dodging the issue, but just not describing with particularity how these consents interplay. So
Yeah.
we have our e-sign consent, which is necessary to get prior to getting prior express written consent. It's kind of bundled up into this one-to-one consent rule. But another issue is our do not call consent. The TCPA only requires prior express written consent when using an ATDS or pre-recorded message. On the other hand, prior express invitation is required to make calls to numbers on the do not call list if you don't have a EBR. The December order kind of muddied the water on whether DNC rules require one-to-one consent. The precise language in the statute essentially holds that the DNC rules do not apply when the seller has obtained the subscriber's prior express invitation or permission. Such permission must be evidenced by a signed written agreement between the consumer and seller, which states the consumer agrees to be contacted by this seller. So that language kind of indicates that DNC consent has to be one-to-one too. The FCC, no, just a reminder, the FCC didn't take it the next step and say one-to-one consent is required for DNC consent, but the language on its face, that by this seller language, there's an argument that does require one-to-one consent, and that's something that we think that the plaintiff's bar is going to take up. And there's some interesting risk points. The FCC has provided the inconsistent guidance on whether DNC consent is to be one-to-one. There was the letter from several state attorney generals that stated that the TCPA and similar state laws already require one-to-one consent. So we have these kind of risk points that kind of tend to indicate that DNC consent has to be one-to-one.
Yeah.
So
And I know from our firm, I think sometimes we're a little bit more conservative on this specific point because, we really are concerned what the plaintiff's bar is going to do with this. Regulators already have the opinion that the DNC consent, required, one-to-one consent was required for prior express invitation. And so, I think, Aaron, you make some great points here. And I think, from our perspective, if you really want to avoid trouble, we should be considering, the risks that you just mentioned, that DNC consent does require one-to-one consent.
Yeah, and if that is the case, then, for simplicity and uniformity, the prior express written consent standard might be the one to use across the board. Now, that's going to require a lot of changes, and may present complications under more onerous state laws, but it may be the best way to create a uniform standard across the board. So that's kind of a brief overview of our prior express written consent under the FCC. Got to be one-to-one. We've got these new one-to-one standard logically and topically associated. We know we have to get our e-sign consent now. We, the jury's still out on the best or the, I guess, the lawful approach to DNC consent. So I think this is a good segue into our CMS one-to-one side of the presentation. But before we get into that, Ben, could you just explain really quickly the difference between prior express written consent under the FCC's rules and permission to contact under the CMS Medicare marketing rules?
Yeah, absolutely. And there definitely can be some, interplay between prior express written consent and permission to contact under CMS's rules. But when we're talking about prior express written consent in the TCPA context, we're talking about something that's tied to specific technologies. You're making telemarketing calls using certain regulated technologies, an automated telephone dialing system, pre-recorded messages, artificial voices. And so that's what we're talking about when we're talking about prior express written consent from the TCPA perspective. When we're talking about permission to contact, the CMS rules are clear. They prohibit unsolicited contact to a particular beneficiary, which can include telephone solicitations, robocalls, voicemail messages, text messages. So you can't make unsolicited calls to beneficiaries, but if you're using certain regulated technologies to make calls to those individuals, like an ATDS, pre-recorded message, artificial voice, then we're going to need prior express written consent from a TCPA perspective, bundled with, a permission to reach out to that specific beneficiary. And I think this is where, obviously it's a perfect segue into what the CMS has now put out this past spring regarding, the 2025 contract year and the Medicare Medicaid rules. And so in the CMS's final rule that came out in April, they specifically emphasized that they had concerns with that TPMOs are selling and reselling beneficiary data and contact information to what they called skirt existing CMS rules that would prohibit cold calling, so that they can aggressively market these Part C, Part D plans, and that beneficiaries were completely unaware that by filling out and agreeing to a consent to be contacted on an online form, that information was being collected and sold to a bunch of other TPMOs for future marketing purposes, and they're getting a barrage of robocalls. And obviously, we're not talking about the good actors here in this space. We're talking about people that are obviously trying to skirt the rules. They're trying to cut out these bad actors, which, all of our clients out there and those that we deal with, we know there are so many good actors out there, and it's these bad eggs that are ruining this. And so what specifically CMS said is that any personal beneficiary data collected by a TPMO for marketing or enrollment purposes, or for marketing or enrolling that beneficiary into a Medicare Advantage or Part D plan, that data can only be shared with another TPMO when the beneficiary has provided prior express written consent. And so this rule is kicking in here as open enrollment is starting. It's kicking in on October 1st, 2024. So I'm assuming everybody on this call has got their ducks in a row and they're ready to go with their prior express written consent requirements that the CMS has rolled out. But Aaron, as we kind of unpack this, what's required on behalf of TPMOs for this prior express written consent, can you go ahead and just kind of unpack what we mean by personal beneficiary data?
Yeah, so CMS has said that includes any information given by the beneficiary for the purpose of finding a Advantage or Part D plan. And that would include contact information, like your name, address, and phone number, and really any type of information that the consumer is sharing to find the plan that they're seeking.
Okay, perfect. Yeah, I mean, and it's pretty much everything under the sun. Someone goes onto an online lead form or something like that, enters their name, phone number, that for the purpose of being contacted about those plans, that's personal beneficiary data. And so just unpacking the specific data sharing consent requirements here that the CMS is now imposing. This consent, this one-to-one consent that TPMOs have to comply with, is generally consistent with the FCC's one-to-one consent rule. They even, cited to the FCC's one-to-one consent rule in the final rule that came out with this new consent requirement. And so what TPMOs have to do here is they've got to obtain prior express written consent through a clear and conspicuous disclosure for each TPMO that will be receiving the beneficiary's data. And so this is clearly tracking with the FCC's requirement. And so the CMS even specifically points to the FTC's guidance on what clear and conspicuous means, and has encouraged the TPMOs to reference these numerous examples that the FTC has provided. And so, when we're talking about what this means specifically from a one-to-one context in the TPMO structure and how this is going to work practically, the TPMO is not able to share beneficiary data with a TPMO that is a completely different legal entity unless they have prior express written consent. And so what this is saying is that this includes sharing information with another legal entity that shares the same parent organization. So you've got an FMO with independent agents that work under it. You've got to get consent for all of those different legal entities to share that to share that beneficiary data. And so, Aaron, are there some concerns here when it comes to, so we're talking about, in this context, a lot of times making outbound calls. And so we can't share that data so that these other entities can make outbound calls to these beneficiaries. What are the concerns when we're talking about inbound calls?
Yeah, so big difference there, and CMS rightfully acknowledged that difference, and they expressly stated that we do not need prior express written consent to transfer data to another TPMO if that other TPMO can immediately assist the consumer, and the consumer verbally agrees for the transfer of their data to that other TPMO. So the key there on inbound on consent for inbound calls is that the TPMO that the call is being transferred to can immediately assist the party calling, and the consumer verbally agrees for that transfer of data. So kind of getting away from our written consent, but we still have to get verbal consent for inbound calls.
Okay, got it. No, extremely useful. Okay, so yeah, we've got this, this groundbreaking new rule that we have to comply with here in just half a month or so. And so, keep in mind, from the TPMO perspective, you're going to need prior express written consent with each beneficiary to be able to share their data with other TPMOs. And so we've got to get practices in place, that are practical, that can meet our business needs to reach these beneficiaries and to allow our businesses to operate. And so I think that's a good segue, Aaron, into some of the questions that maybe we received prior to the webinar. Do you want to go ahead and address at least the two questions that we got before the call?
Yeah. So, just a reminder here, you can submit questions. We'll be happy to address them. We had a few that came in early, so we'll tackle those right now, give you some time to think of questions if you have any. And then we have some practical considerations that we want to share. But one of the first questions that we got was that in the warm transfer, if a consumer gives consent to company A to discuss a need, and while on the phone, company A matches the consumer with another company, say company B, and obtains oral consent to transfer to company B, is that oral consent FCC compliant? So there's, we'll approach this under the FCC arm and under the CMS arm. We didn't have we'll assume that this is a Medicare product. So under the FCC, if we have a warm transfer, it's an inbound call to company B. It's not company B initiating the call. So our prior express written consent obligations, which remember tie to using certain technologies, ATDS, PRM, artificial voice, we don't have to worry about that prior express written consent for this call, because it's an inbound call. Now, if we don't complete the sale, or if we know we're going to have to call that individual back in the future, and we're using one of these technologies, then we will have to find a way to get prior express written consent to call the consumer back for our prior express written consent purposes. On our DNC side, there is a great argument that an inquiry EBR has been created. So we would have 90 days to contact that individual. But if we wanted to solidify our calling and make sure that we have the proper consent, well, then we'd have to once again, find some way to get that consent to call that individual back for whatever reason if we have to. Ben, you want to hit the CMS angle on this one?
Yeah, absolutely. So, like we mentioned before, when we're talking about the CMS rule, and we're talking about inbound calls, you're not needing the prior express written consent under the new CMS rule to transfer data to a TPMO that can immediately help the consumer with the call and who verbally agrees to be transferred. And so in this instance, you know, I kind of would liken it to that situation here, you know, where we've got company A on the phone. They say we've got someone that immediately can help you. And under that rule, you know, they can immediately transfer over to the other entity that's able to field the call and help them with that. And so segueing from that, you know, from that specific angle, Aaron, and this is another very broad question that we got asked. I guess everybody's concerned about inbound calls, but what rules do we need to be aware of from both the FCC side, from the CMS side, when we're talking about inbounds calls outside of needing to have, you know, compliant creative materials?
Yeah, so at large, I guess it parallels our first question that we answered, you know, whether we need to call that person back would determine our what we should get on the phone or ask the consumer to consent to while we're on the phone. So once again, if we are planning to call this consumer back with one of our regulated technologies, then we're going to have a process to get prior express written consent. Remember, that can't be over the phone now because we have our Bradley holding. So it's going to have to be, you know, through text or email, some way that we can get our e-sign consent and our prior express written consent electronically. And the concern with the DNC is largely the same with our first question. There is likely an inquiry EBR created when a customer calls in and inquires about our products or services. So we have that 90-day exemption time period to call a number on the do not call list without consent. But if we want to solidify our calling to this consumer whose number may be on the do not call list, we'll want to get DNC consent on there as well.
Yeah, no, definitely agree wholeheartedly on that. And so I'm taking a look at the open questions right now. We don't have anything popping in, so if you do have a question that you want answered, Aaron and I are very happy to field that for you. But you know, I think as people join this call, they're wanting to hear you know, some practical considerations on how their business can operate under these two new regimes for consent purposes. And so a common question that I think we're fielding from a lot of our clients right now, Aaron, is what do we do with old leads? You know, we've got years and years worth of leads under the TCPA, prior express written consent before it doesn't expire. So can we keep using these leads? And what do we need to do come you know, for the TCPA January 2025 or from the CMS side? What do we do with leads we've you know, generated very recently come October 1st? Can we use those leads? And I think from a benefit, you know, from the CMS side, no. If you have not gotten prior express written consent that's compliant with this new rule, come 10/1, you're not grandfathered in for any of those old leads or anything like that. You've got to comply with the new rule for all leads starting October 1. And then you know, on the other end, as far as the TCPA, there is also no grandfather clause there. If you're using an ATDS, you're using a pre-recorded message, artificial voice, you've got to start on January 27th, 2025. Your consents need to be compliant with the prior express written consent rules from the FCC's newest order. Otherwise, you don't have prior express written consent, and you're in direct violation of the PEWC rules and the TCPA.
Yeah, and I think we sometimes see people getting a little bit more confused than probably necessary, because they think, oh, well, then starting that day we have to create new leads. It's not so much the date that the lead was submitted that matters. It's the date of the call and whether the consent for that call meets the new standards that kick in, for CMS on 10/1 and for FCC on 1/27 of 25. So it's our when we make those calls after those dates, are we using leads that are compliant with the certain standards?
Yeah, absolutely. Good point. Very good point.
Yeah. So moving along with our practical considerations, we talked through the e-sign act, but just to highlight that again, we have to get that prior to getting prior express written consent. That's our gold standard. We think that there will be some who approach it getting our e-sign consent and prior express written consent at the same time. I think there will be some that will continue to rely on old FCC commentary that the full formalities of the e-sign act are not required, and that we don't have to get any e-sign consent at all. And there will probably be some folks that try to get e-sign consent after our prior express written consent, but the timing is important here. We want to minimize impact on consumer experience, but we know that e-sign consent is required prior to getting prior express written consent.
Yeah, no, that's great. And then from obtaining prior express written consent, what we're seeing now and what we're expecting to see in the industry here, some ideas of how can we practically go out there, not ruin the customer experience, but comply with these laws. I fully expect, the large lead generators, the sophisticated parties out there to start making use of dynamic forms and web pages so that they can gather information throughout that practice, throughout those dynamic forms, and end up with a TCPA disclosure statement with a single seller. And I think there's going to be a lot of people using that specific model. I think from a compliance perspective and a legal perspective, that's an extremely smart way to go about this issue, and also it's a high quality lead. That lead is going to be extremely useful to the eventual seller.
Yeah, I would agree. Another approach that we're seeing some clients take is providing a list of entities and asking the consumer to select which entities they want to receive calls or texts from, using an ATDS pre-recorded message, or the entities to which the consumer wants the TPMO to share beneficiary data with other TPMOs. If you're planning on that approach, the consent language and the list of entities on the same page is the most ideal. We have seen some folks do a list on page 1, and then the consent language on page 2. Or I got that backwards. Consent language on page 1, where they say, we have this list of marketing partners, do you consent to be contacted by them? And then on page 2, they have a checkbox where you can check the individual entities that you want to receive calls from. So consent language first, then the checkbox of list of entities. Another common trend we're seeing is some clients moving to an affiliate marketer model where they're driving traffic to their own their own lead forms that they host, or for some of our generators, they're driving traffic to a seller hosted lead form, but somehow driving consumers to a page where that they can give consent directly to that seller on the seller's own pages.
Yeah, no, and I suspect, Aaron, that there's going to be some folks out here that probably continue, their current practices, right? I mean, there are situations where, people are saying, we don't use any regulated technologies. I'm not using an ATDS. I'm not using pre-recorded messages or artificial voice. So I don't have to worry about prior express written consent. I don't have to worry about one-to-one consent. From a TCPA perspective, like we said, there could be some risk in that. We don't know what's going on. But certainly from the CMS perspective, you're going to need to get prior express written consent to share beneficiary data with other TPMOs. So please make sure you're on the TPMO side, you're listening to us on that point. Aaron, just while we're going through this, we did get a question from one of our participants. They asked about on the selection list, you've got all your various entities listed. Is it okay to have a check all box? So, we've got a list of 10 or so folks, entities that we, consent to be contacted with or share beneficiary data with. Can we have a box that simply just says check all, that will automatically check all the boxes?
Yeah, and that's a great question, one we've addressed a lot, and there's risk there. We certainly don't want the boxes pre-populated where the consumer would have to go in and uncheck all. Whether if the consumer does hit the check all, that indicates that they do want to hear from all of the individuals. I mean, it's not as safe as having the consumer check each individual seller that they would like to hear from. But it's if that's the consumer's decision, if that's what they want to do, then there is a strong argument that is one-to-one consent, but there is some risk there due to the fact that that it's the consumer checking one box to receive multiple, or to indicate multiple entities who they wish to hear from.
Yeah.
Is that your thoughts, Ben, or would you?
Yeah. I mean, I would agree. I think this is, there is some risk, but when is there not, some risk, unless you're completely compliant 100% and potentially, not able to make any money here. But I do think there is a strong argument that checking a check all box is an affirmative action, affirmative consent by the consumer, and I think that's a creative option for folks that are trying to get together their prior express written consent workflows, and definitely something that they should consider when they're putting together their online forms and their consent forms.
Yeah. I mean, overall, we know that we can't list several sellers under our marketing partner hyperlink to obtain consent for multiple sellers. We can provide a list of sellers and require them to check the box for each seller they want to contact. I think our best route is to individually check those boxes, but that there is a strong argument that a check all box is effectuating the consumer choice.
Yeah, absolutely. I fully expect to see, a lot more usage of, advertisements that drive inbound calls, obviously with the exceptions under the CMS rule, and under the TCPA. I think that's going to continue to be, a main factor, and something that businesses should consider if they feel like, getting prior express written consent is too onerous. Maybe they should invest more in these click to dial campaigns, to try to drive inbound traffic, and limit the risks that come with potentially not creating a compliant prior express written consent workflow. Um, uh, so Aaron, do you just want to highlight, just for the group, as I'm not seeing any other questions. So if there's no other questions, I feel like we should, I don't know, give a very high level, what is not permitted moving forward. Do you want to kind of tell us right now, what is your main, what we cannot do moving forward under these rules?
Yeah, the what we cannot do, as I just mentioned, is have that list of several sellers get that's under a marketing partners hyperlink, and with a single consent mechanism. We cannot have that list, and we cannot get single consent. It has to be one-to-one. And as we started out here, the new FCC rule, the bottom line is that forms cannot obtain prior express written consent for multiple sellers through a single consent mechanism. So avoid that.
Yeah. Yeah. And make sure, if you're moving forward, what you can do is you can provide a list of sellers. You can require the consumer to individually check those boxes, like Aaron said, potentially using a check all box that they affirmatively check. Those are options that we can do to allow each seller to contact those individuals using an ATDS pre-recorded message, or artificial voice, or in the CMS context, doing the same thing for sharing the beneficiary data. We appreciate everybody joining us today. If there are any further questions, our contact information is here, on the slide here. Like I mentioned before, this. Oh yeah, go ahead.
Oh, never mind. You got us. You got us on our handy dandy chart here. We make sure we know that the QR code is for our handy dandy chart. I mean, I use it daily.
Hey, don't leave home without it. It's very easy to reference this. It can get confusing when thinking about the consent workflows all the time. So it's easy to have that reference there. So yes, please use the QR code to get that. Links to our website and our social media pages are there on the side. It's been a great webinar. We appreciate the questions that people submitted beforehand and the questions that people submitted during the call, and look forward to navigating this space with you. Thanks, Aaron, so much for all your great insight and points. Obviously, a pleasure doing this webinar, and look forward to doing more in the future.
Awesome. Thanks a lot.